Datuk Kamarudin Jafar, Datuk Sri Wan Aziza, Wan Ismail, Leader of the Opposition, Sadr Azmin Ali, Menteri Besar, the State of Selangor, the man of the hour, Mr. Mark Trowel, can we give him a big hand? Datuk Ambika, my fellow speaker, ladies and gentlemen. The person who's actually supposed to be standing in front of you here right now and speaking is a gentleman called Mr. Stephen Thiru. I am not Mr. Stephen Thiru, as is quite obvious. Mr. Stephen Thiru, I think, would have been the better speaker for tonight as the president of the Malaysian Bar, and probably would have given you a slightly more objective account compared to what I'm probably going to say in a few minutes, but for some reason was unable to make it. And so after my wife and I arrived for dinner not too long ago, halfway through the dinner I was told dinner is not free. You have to speak. So you're supposed to sing for the supper. But so anyway, so let me just share my thoughts with you as they unravel in my mind tonight about a very important book, the book that has been put together by Mark Trowel QC, a comrade in the law, and who I regard, I hope he does, I regard as a friend. A book that will remain an important annal in the history of the law in Malaysia, nothing less. I remember some months back when Mark, in one of his usual generous moods, he treated me to dinner at his hotel, and we were discussing the book. And he said, I'm calling it The Prosecution of Anwar Ibrahim. And the very same thought which Ambika just shared with you came to my mind. I said, Mark, we should be calling it The Persecution of Anwar Ibrahim. But Mark said no, and quite rightly, because Mark Trowel was always wanting to be, and rightly so, the impartial, independent observer. And that is the important role that he has played in this episode from the first time he got involved until the conclusion of this book. And that is why his views, the words he writes here, the views he records here, and which are now being carried all over the world. International justice groups, international legal groups, the United Nations Working Group on Arbitrary Detention, the International Parliamentary Union are prepared to take a position because they know it is coming from a distinguished barrister with his background, his track record, and written in that dispassionate, objective, independent manner. So he gently declined my invitation. I said, Mark, all you have to do is just take these two letters out, R-O, cancel it out and just write E-R. And that would do it. You could leave the prosecution there, but everybody will know what you mean. Mark said, no, thank you, Siva, we won't do that. But I don't have to be as dispassionate and independent and, as Mark has to be. I think this very important book is really about the biggest injustice that has ever been perpetrated by a court of law in Malaysia. And this was done for the second time when the Court of Appeal and the Federal Court convicted Anwar Ibrahim of an offense for which there was no evidence and jailed him for 5 years. And I am prepared to say in any forum, and I will say it now, that this was not a legal judgment, that this was always a political trial, and this was always going to end up in a political judgment. And that's what this case is about. This case is not about the law. This case is about politics. And as Ambika rightly pointed out just now, to understand why it is a case about politics and not about the law, we go back to the context of the entire case. And Mark, you rightly start the story 17 years ago. Because the story, that's the way the story has to be told. It started 17 years ago, when after his removal from UMNO, as the former Deputy Prime Minister and the former Deputy President of UMNO, and Sadr Azmin was very much part of that struggle with him all the way. Anwar was clearly the most significant threat, political threat to UMNO and the Barisan Nasional. And that's why he had to go to jail. And to somehow make that jailing, make that imprisonment acceptable, it had to be done through the legal system. And that's where we saw, yet again in this country, the institution of the judiciary manipulated to that end. And we all know from the first conviction, Mark, you started by saying, Karpal recorded legal history when he was the first lawyer to be charged for something, a lawyer for submissions in court. And likewise, I think, Anwar Ibrahim, I don't think we'll ever find a parallel where a person who was in such high political office, Deputy Prime Minister, and now at one point he had about 6 sodomy prosecutions placed against him. It's almost ludicrous. And 5 of them were started in 1998. Only 1 was concluded. There were other charges which were pressed, which were presented but withdrawn. And you don't need to be much of a lawyer. I think the Malaysian population saw how ridiculous the charge was in 1998. How you had this ridiculous witness called Azizan, the former driver, standing in court and saying he was sodomized on this particular date, on this particular year, and his testimony then blown apart by counsel for the defense when they pointed out the building didn't exist on that particular date and time. The building in which the so-called event happened. That was the absolute lack of quality in the case that was presented in 1998. And yet we could have the judiciary at that time declare that this witness was as solid as the rock of Gibraltar, the exact phrase used in the judgment. But one thing we have to accept, they presented a crude case in 1998. They learned from that. They learned that you have to be smarter if you want to do it again. And one thing we have to concede to the various institutions that were involved, starting from the police, the Aegis chambers, and the judiciary, that they did it smarter this time. They put together yet another fabricated case, but they did it smarter. So, as Mark rightly starts the story from there, because that is where the political conspiracy starts. Anwar was a threat. He had to be put away in jail. He had to be shamed in the eyes of the Malaysian public to try to destroy him politically. And what's better than a charge of sodomy? And we cut now quickly to 2008, where Anbiga just said, Anwar emerges again after the first detention of 6 years. And instead of walking away from all of it, he stands there, he provides leadership for the country. And he brings it all back together again. But what does that mean? That again, Anwar Ibrahim becomes the single biggest political threat to the continued existence or survival of UMNO and Barisan Nasional. That's what was the reality. And so the plot had to be done again. Anwar Ibrahim had to be sent back to jail again, had to be shamed yet again in another episode of sodomy, so-called sodomy. And we saw the conspiracy start all over again. Different actors, Different script, same objective. And that's what we have seen from 2008. And Mark was part of that as our friend from Australia who came on behalf of the IPU. And thanks to him today, we have this very important record of what took place. Now, as he said, we can disagree with some of the things the trial judge said or agree with some of them. But I would say, despite the lengthy Court of Appeal judgments, despite the equally lengthy federal court judgments, this judgment remains a political judgment. It remains a gross injustice where an innocent man was convicted simply because he was a political threat. And I will try to present that in just this way. I could spend the next 2-3 hours, many hours, and Mark knows this very well, if we were going to discuss the credibility of the complainant Saiful Buhari. We could stand here and talk for hours about what happened with Dr. Osman, what happened to the plastic bit that was supposed to be up his bottom. We could go on and on. We could go on and on about his police report, where he complained about sodomy about 9 times all over the place. We could talk about that he could enjoy rough sex and yet have curry puffs and coffee, I think, after that. That was the story. How the missing carpet, which Counsel Gopal Sriram brought up in the federal court and so on. We could go on and on about that. But ultimately, and I think Mark tells this story very well in his book, how the trial judge, Justice Zabidin, despite all the pressures brought on him, and how we thought it was so clear that Anwar would be convicted, that even he had to recognize the case had such a big hole in it that could not be covered up. And what was that? And this is where Zabidin felt he couldn't cross the line. It was just too much a travesty of legal honesty, you couldn't cross it. And this was because when the samples were taken from Saiful's bottom in the hospital by the doctors, they were carefully put into test tubes, sealed, labeled, and they were put into a plastic bag which was hot sealed, permanently sealed. And this was done in front of the IO, the investigating officer, Jude Pereira, in front of him. And what did Jude Pereira do? This is on Saturday night, 26th of June, 2008. What did he do? Instead of delivering that bag straight to the chemistry department the next morning, as a responsible investigating officer would have done, he kept it in his filing cabinet. Not only did he keep it in his filing cabinet, he cut open the bag. He cut open the bag. And this was what Justice Zabidin said, I can't accept that. There was no good reason for him to open the bag when the bags were sealed in front of him. There was no good reason. And as the defense experts from Australia, Dr. David Wells, Dr. Brian McDonald said, in any court in the world, in front of a fair judge, the case would have been thrown on that alone. When the investigating officer cut open the bag and said, I had to reseal, I had to repackage the samples in a different bag. So, on that alone, the case should have been thrown. And Justice Zabidin did throw the case on that ground alone. He said, I can't accept the explanation of the IO. He said, I had to open the bag, I had to reseal it in compliance with IGSO, Inspector General Standing Orders. He said, I don't buy it because it was sealed in front of you. And You knew how it was sealed. Why do I therefore maintain it's a political judgment? I make my case simply on the basis of how the Court of Appeal behaved. If any of you have the time and the inclination, Mark's report to the IPU, the Inter-Parliamentary Union, about the Court of Appeal is there for all of us to read. It's a scathing report, and rightly so, because the Court of Appeal showed to the world beyond any doubt that this case was about politics. It wasn't about the offense. And why do I say that? Because the appeal was fixed for April 2013 to be tried. April 2013. The dates were fixed, 10th to the 14th. Karpal's office was informed. Everybody was clear about it. But suddenly, lo and behold, what happens? Karpal is summoned to the chambers of one of the trial judges. The case is fast forwarded to the 6th and 7th of March, 1 month earlier. Karpal says, I'm sorry, I've got cases on that day, partnered cases in Johor Bahru and somewhere else. No, don't worry, we are going to postpone those cases. This case must be heard on the 6th and 7th of March. And why was that, ladies and gentlemen? Some of you may remember the key event what was going to happen on the 11th of March. And what was that? Nomination day for the Kajang by-election. You couldn't get it more blatant than that. That the agenda had been set. Anwar Ibrahim, who had announced his intention to run for the position of Adun in Kajang, which now of course Dato' Sriwan Aziza, and of course from then on to move to the position which Saudara Azmin is now occupying, it was very clear that that had to be stopped at all costs. And how could you stop it? The judiciary had to do it. And that's what the judiciary did. The judiciary played out the script which somebody else had written. So you can't get a clearer demonstration of the political judgment that was rendered. It was not a case about the facts. Because, and I use the Court of Appeal because that is where you see the nakedness, the political nakedness behind this judgment. But I must say, the federal court was a lot smarter. The federal court was smart. They gave us a very patient hearing, didn't they? 8 days. Apparently is now the longest criminal appeal in the history of the federal court. And that's just to prove how patient they were and how they allowed defense counsel to say everything that could be possibly be said on behalf of the appellant. And so it was said. But the outcome was no different. Because everybody knows that the political threat in the person of Anwar Ibrahim still had to be dealt with through the system. And Mark puts it very judiciously, impartially. He says, there wasn't sufficient evidence to convict. I totally agree. As I said earlier, if you go to the facts, you could demolish the credibility of Saiful. I mean, that's not too difficult to do. But leaving all that aside, as Justice Abidin did, he threw the case out just purely on the fact when the IO cut open the bag. And the other aspect, I think, on which probably any fair court in the Commonwealth, applying the same rules, the same principles, would have thrown the case, was on the DNA. And let me tell you that story, because it's a nice little story which Mark tells in his own words, and I hope I just capture the essence of it for you. Well, it's about semen and DNA, 2 parts to it. One is the fact that Anwar Ibrahim turns out to have superhuman semen. Because the semen is somehow able to produce analyzable DNA when it's obviously physically, not supposed to be able to. After 60 over hours, 96 hours, thank you, Mark. After 96 hours, it is still capable of being analyzed and producing results. History, in terms of semen analysis, forensic analysis, and so on. That alone would have been a major question mark. But the other aspect of the DNA was this. And this was a story, and this is based on the prosecution story. And I'll wrap this up in a few minutes. This is Jude Pereira's own narrative, the story in court by the prosecution. Saturday evening, or the incident is on Thursday. So the DNA is sitting in the, so-called, sitting in the boy's anus from Thursday to Saturday. On Thursday night, on Saturday night in the hospital, the samples are taken, put in the test tubes and put in the bag. And they're not kept in a fridge as they were supposed to be, they're kept in a filing cabinet until Monday evening, and they arrive at the chemist at 7 p.m. on Monday. And this is the story told by the IO himself. This is what he did. And the defense experts, and this is where they demolished the case by saying, Dr. David Wells and Brian McDonald pointed out two key things. One, Brian Wells pointed out the seals on the test tubes within the bag that Jude Pereira cut open, those seals were actually removable seals, which was why it was so important that bag should never have been cut open, the bag that was hot sealed. Now, then what Dr. Brian McDonald said, and Brian McDonald is a global expert on DNA. He writes the textbooks, he lectures the experts on DNA. And he said this. He said, going by the prosecution story, the DNA that arrived in the chemist's lab on Monday must show a serious amount of degradation. Based on the prosecution story itself. It must show it, because it wasn't kept in a fridge, high temperatures, it is going to degrade. And when you test the DNA, you will see the degradation in the reports, in the profiles. And when the reports were shown to him, the profiles were presented and asked, Ram Karpal asked, Dr. McDonald, don't you agree that these profiles show pristine DNA? Dr. McDonald said, yes, this DNA is pristine. And that itself would have thrown the case. Because what Professor McDonald was saying was, the DNA that was being presented in court, or the profiles that were being presented in court, were not the DNA that was supposedly taken from the complainant's anus on Thursday. So, I mean, we don't have the ridiculous story that Azizan told in 1998. You know, the story that he was sodomized in a building that didn't exist. And as I said, the prosecution got it smarter. Well, not the prosecution, the conspirators put together a smarter job, but it still wasn't good enough. And the story should have been thrown. The case should have been thrown. And ladies and gentlemen, I think we all have to thank Mark Trowel here for the service that he has done to our country and to us as Malaysians, for having put this together. And this book, and I hope that in the near future we will translate the book, because I think this story has to be told in Bahasa Malaysia to our entire people, for all of us to understand that this is not just about Anwar Ibrahim. This is not just also about Anwar Ibrahim's family. In manipulating the judiciary, in doing the injustice that they did, the injustice is to Malaysia, to us, to the whole country. Why? Because the institution has been damaged and manipulated. And I think for lawyers especially, for those of us, Amiga, a number of probably in the crowd who go before this institution, I think we feel the pain. I felt it that day on February 10th, when I saw the judgment being rendered. I felt the pain. I felt the emotion, because for lawyers like us who go before that institution on a regular basis, pleading our cases, making our arguments, and to see the way the institution was being used, because a political threat in the person of Anwar Ibrahim had to be stopped. That was sad. Not just sad, it also made us angry. But for all of us sitting here as citizens of Malaysia, it's a reminder to all of us of the challenges that we face. The duty that all of us must undertake. And that duty is no less than to fight this battle, to fight it in the way Anwar would want us to fight it well, fight it to the end, so that generations after us will be able to enjoy true freedom, true independent institutions, a real democracy where the judiciary would protect people and not be used to oppress people. Thank you very much.